It's about learning how to dance in the rain. Vivian Green. Good afternoon and welcome to the Bethel Baptist Legal Aid Clinics Forum, COVID and You, Rights and Responsibilities. I'm your moderator, Andre Earl. We're pleased to have you participating in this forum in chapel and online. Our website, as you know, is www.bethelbaptisthwt.com, and the YouTube link, youtube.com/C/Bethel Baptist HWT Jamaica. Let us pray. Heavenly Father, give us the grace to hear your voice and the strength to continue working for your kingdom in this time of pandemic. Do not allow us to be indifferent to those who today suffer the loss of a loved one, are suffering due to COVID-19 or other health challenges, or who suffer from the absence of work. We pray that your healing and supporting hand may rest upon them right now. We thank you, Father, for the opportunity of sharing in this forum this afternoon. Give us a better understanding of our legal rights and responsibilities during this COVID-19 period, and continue to bless the work of the Bethel Baptist Legal Aid Clinic. Please be with the presenters, technical team, and myself as moderator, that we will have a well-executed and engaging forum in which we may all benefit from the industry and research of our panelists and the exchange of ideas which will follow. Help us to make the most efficient use of our limited time. We ask that everything that we do and say this afternoon will be done to your glory, honor, and praise. In Jesus' name we pray. Amen. Bethel Baptist Legal Aid Clinic operates on Saturdays from 10 a.m. to midday and has been doing so for the past 20 years, serving the community and supporting some of the other ministries at the church. We have also helped other churches set up legal aid clinics. Since COVID, we have adopted the hybrid model of meetings. So we have face-to-face and virtual meetings with the public. The face-to-face occurs right here at Bethel, 6 Halfway Tree Road, and all protocols are still observed. And for the virtual, you simply have to call the church office, 876-926-8272, Mondays through Fridays. Leave your contact information, and a rostered attorney will contact you. Or you can email us at bbclegalaidclinic@gmail.com. The decision to host the series of fora to reach more people was recently arrived at, and we have decided to hold one such forum per quarter. This is our first forum, COVID and You, Rights and Responsibilities, as we still learn to grapple with some of the issues surrounding COVID. No doubt, some of you may be saying, but COVID not keep anymore. Now, whilst that viewpoint is debatable, we need now more than ever to know exactly where we stand, don't we? Can we be denied entry to an establishment, even church, because you refuse to wear a mask? And we saw one example of baby Maya this morning in the 7 o'clock service, trying to get her own mask from the pastor. Or can you be denied entry because you refuse to have your temperature taken? Does an employer have the right to insist on knowing your vaccination status? If you have tested positive for COVID, what are your responsibilities now under the law? How does the Public Health Act affect us now in relation to COVID? Mindful of time constraints, and so as not to unduly impose ourselves on your usual Sunday afternoon activities, we aim to conclude around 6:30 p.m. The panelists have had prior notification of and have agreed to this timeline. In terms of our program, I will introduce each of our panelists separately. Our panelists are Dr. Julia Rowe Porter, Justice Hilary Phillips, CDQC, retired, and Mr. Emil Leiber, attorney at law. Each panelist will then present for about 12 to 15 minutes, after which we'll have a brief panel discussion, then a Q&A for 25 minutes or so, closing statements, and then a conclusion. Our first presenter is a graduate of the University of the West Indies, Bachelor of Science, or Bachelor of Medicine and Surgery rather, which she obtained in 2003. In 2009, she received her master's in public health with distinction. She has had various postings in the Northeast Regional Health Authority, and since 2015 has been with the Ministry of Health and Wellness. She was previously Program Development Officer with responsibility for immunization and child health, and is currently a medical epidemiologist in the Non-Communicable Disease and Injury Prevention Unit. She's a Bethelite, dedicated as an infant, baptized, married here, and is now a deacon. Ladies and gentlemen, please help me welcome Dr. Julia Rowe Porter, who will be presenting from the perspective of COVID and public health.
Good afternoon, everyone. Thanks for having me. And as you can see, I am the odd one out here. I'm amongst lawyers. I'm so glad I'm talking first. And I'm sure you're tired of hearing about COVID after 2 years, and you're probably tired of hearing a public health professional talk on COVID. But my purpose today is really to broaden our appreciation of the context of public health measures implemented during the pandemic. So I will give a few basic principles of public health practice. We'll go back in time looking at the influenza pandemic in 1918, and we'll give some statistics, some current statistics on Jamaica's COVID status currently. Next. So what is public health? Public health is a science and it's an art. So there's a lot of creative energy that goes into it, and there's a lot of strategic decision making. And it's focused on preventing disease, prolonging life, and improving the quality of life. It's very organized, it's not haphazard, and it really enables society to make informed choices. It involves the public and private sector, various community players, and the individual. So public health is very broad, and it's very principled in what it sets out to achieve and how it does it. So a few principles of public health include equity, fairness, and inclusiveness, with emphasis placed on protecting the marginalized and the most vulnerable in the population. Empowerment is key because individuals and society are supported in making the right decisions. And public health is based on effectiveness and evidence-based practice. So if an intervention isn't effective or evidence-based, it's not recommended or unlikely to be recommended. So a few examples include chlorination of or tap water to prevent gastroenteritis and other infectious diseases, a ban on smoking in public places, and mandatory vaccination for children under the age of 7. Next slide. So we're going to look at public health versus medical care. A lot of us say, if it ain't broken, don't fix it. When I'm sick, I go to the doctor. We're not prevention-minded. But public health really, it helps us to step back and look at prevention. Firstly, public health focuses on the population versus individual medical care. It looks at the individual going to the doctor or with their family. It is primarily guided by public service ethic and then tempered by the concerns of the individual versus medical care where the ethic is personal service. And then you consider social responsibility secondarily. Public health emphasizes prevention, promotion, and this is for the entire community, versus medical care, which emphasizes diagnosis and treatment of a condition for a patient. So the interventions of public health are applied across not just people, but places. So it looks at the environment, human behavior, lifestyle, and it includes medical care. So because public health is so broad, it's mainly government-led versus medical care, which is led by a healthcare provider. Next. So let's go back in time to the 1918 influenza pandemic. Some call it the Spanish flu, although it's said that it's likely to not have originated in Spain, but in the Americas. Now, this is a collage of articles that were placed during that pandemic, and it really highlights a number of public health measures that were implemented. And a lot of it is going to be deja vu. So there was a lot of emphasis on the empowerment of the public with preventive messages. So cover your mouth when you're coughing or sneezing, avoid crowds, avoid public transportation if you can, don't share utensils, safeguard your personal health, get rest, avoid fatigue. If you're sick, go and see a doctor. There was a requirement to wear masks and also a requirement for public spaces to be well ventilated. There was also widespread anxiety at that time, so messages were given for persons to avoid worry and fear and fatigue. And there are also appeals for the public to obey the city ordinances, so there may have been some defiance to a number of the measures that were instituted. There was also rigid quarantine requirements and appeals to the public to help to enforce them. So there's an article at the bottom right that says you are asked to aid in enforcing them. We also understand that there were a number of closures of public spaces. So they closed schools, dances, gyms, theaters. There was a ban on funerals, and even churches were closed. There's an article on the left that says churchless Sunday will be observed because of the plague. Different denominations urged parishioners to pray at home. And there was a lot of burden on the healthcare system with the mass illness and death. So this was taking a toll on the nurses and the doctors, so you'll see a death toll there. It was affecting all frontline workers, including the Navy at the time. There was a need to isolate patients, so there are a lot of field hospitals, and there was mandatory reporting of cases. So the key message really is that this happened 100 years ago. So public health measures are not new in terms of managing pandemics, and they were useful now. So we fast forward, next slide, to today, where we're in the middle of COVID. And just to add, for the influenza pandemic, for decades, countries were urged to prepare for another pandemic, because a pandemic happens when the population is not immune to a new virus. So countries were urged to have national pandemic influenza plans. And one of the well-oiled mechanisms was to have reformulation of a flu vaccine, which was instituted some time ago Some countries have a robust program of vaccinating their population during the flu season, and they change this formulation every year so that if there was a major shift in the virus, then they already had a mechanism to develop or change the vaccine so that we could control a pandemic if it were to happen with the flu. But what happened to us is that this pandemic happened with a coronavirus, and they didn't have an advanced flu vaccine or an advanced vaccine for coronavirus. So really and truly, COVID-19 stands for coronavirus disease, which started in 2019, and that's the name of the disease. The virus that causes it is SARS-CoV-2. SARS is severe acute respiratory syndrome, CoV is coronavirus, and 2 means it's the second of its kind, as the first cause, the first type was actually a SARS outbreak in 2003. So it's been since 2003 that globally there has been a push to develop a coronavirus vaccine. So the vaccine actually isn't a new, it didn't just jump up out of nowhere. Next slide. So we know the stories and what has happened with COVID. There was threats to health and life, there was fear, there was not just a health crisis, but a psychosocial crisis, and this had several repercussions with the measures, with isolation and quarantine, causing social and economic crisis, and this had an individual level impact as well on the family and children with stress, unemployment, and anxiety, depression. It was really a significant mental health crisis. I want us to pay attention to the top right corner where it says around 25% of COVID-19 infections could have long-term symptoms. So if you were saying, let me just get it and done, I'm young, I'll probably have mild symptoms, then you could have long-term symptoms even if your initial infection was mild, and these include fatigue, shortness of breath, cough, joint pains, chest pain, cognitive issues like memory problems, difficulty concentrating, depression, muscle ache, rapid heartbeats, and even intermittent fevers going forward, and we're not sure how long that can continue. Healthcare workers were burnt out. The pandemic had a significant death toll, and in fact, the death toll that is reported is perhaps more than what really has been reported, because there are some deaths that may not have been tested for COVID that may have been attributable, and there are some countries that have actually noticed an increase in myocardial infarctions or heart attacks and strokes that may have been attributed to COVID. We note that for the US, they're saying that COVID was actually worse than the Spanish flu. The full has not been told also of the economic impact and the impact of children in our schools. Next. So we're going to look at where we are in Jamaica. We had 4 waves. The 4th one just ended, so we're seeing the back of it now. And for the 3rd wave, this one was the deadliest. This is a graph showing the number of cases, the deaths, the bed occupancy during COVID. We noticed that the 3rd wave was the deadliest, and for the 2nd, 3rd, and 4th waves, bed occupancy at hospitals actually exceeded 100% for each of those waves. The trend now, because this is from March 13, there is more recent analysis done as of last week, which shows that we're still trending in a positive direction. Our indicators are all looking good in terms of the number of communities that currently have active cases. There are only 16% of those communities. But even though things are looking good, vaccination rate is still low, and that is a major concern. Next. We look at deaths from COVID, and this is really showing that really and truly every age group had a risk of death. Even persons less than 30 years old, their what you call case fatality rate, which is the number of deaths per person that had COVID. And 0.1% of persons that had COVID under the age of 30 had deaths. And this went to a high of 20.4%, or 1 in 5 persons aged 90 and above. Next. So the key message really from that is that all persons, there's a risk of death and severe illness from COVID in all age groups. We look at our vaccination status of the persons that died, and this is really showing that vaccines did indeed protect against deaths. And this is Jamaican data, where as at March 13, we had 2,310 deaths analyzed, and of those, 98% of those persons that died from COVID were unvaccinated. And only 1% approximately 1% were partially vaccinated or fully vaccinated. Next. So our vaccination rate is abysmal. Less than 25% is our population vaccination coverage. And not even in the more vulnerable age groups are we satisfied with the coverage. So for ages 60 to 79 years, the coverage was of fully vaccinated persons was less than 40. And our target was supposed to be 65%. Next slide. I end by saying this. Vaccination is still relevant and it's effective and it's still recommended. Don't mind the small print in the infographic to the right. What this is showing is that for every dollar that is invested in certain public health interventions, and they include examples, immunization, preschool education, public infrastructure, investing in community health workers, cardiovascular disease research, all of them give a return on investment, meaning for every dollar spent, then you can multiply your impact in terms of getting economic benefits from these interventions. And what this is showing is that immunization gives the highest return on investment. So for every dollar invested in immunizing children, especially vulnerable children in vulnerable countries, you multiply your investment by to $16, which is a lot more than the other public health interventions shown there. And what this means is that immunization is one of the most cost-effective public health interventions because it has an excellent safety profile and it has proven its effectiveness over the years. And it saves healthcare costs and minimizes lost wages and productivity. So those are the stats. And we're pleased to say, I'm ending by saying, we're pleased to say that Bethel is now a COVID vaccination site, so you can come to Bethel. We are pushing the message to support the population to understand the risks and that they still need to get vaccinated. Now is the time. So thank you.
Thank you very much, Dr. Roe Porter. Our second presenter is a graduate of St. Andre High School. She was admitted to practice as an attorney at law in Jamaica in 1974, worked in various private law firms, and was appointed Queen's Counsel in 1998. She's a former member of the Jamaican Bar Association and was its president during the period 2001 to 2004. She's a former member of the General Legal Council. She was appointed to the Court of Appeal in Jamaica in 2009 and acted as its president in January to April of 2019, making her one of only 3 females in the history of the Court of Appeal to have done so. She retired from the bench last year and is currently chairman of the Judicial Services Commission of the Turks and Caicos Islands. She is a recipient of numerous awards, including national honors, the Order of Distinction in the rank of Commander for distinguished and dedicated service to the legal profession and the judiciary. She's a member of St. Andrew Parish Church, and at this time, I'm going to invite you to join me in welcoming Justice Hilary Phillips, CD, QC, retired Judge of Appeal, who will share her perspective on COVID and constitutional rights.
Good afternoon, all, and thank you for that introduction, Andre. So this evening, I'll be speaking a little bit about the legal perspective. The Disaster Risk Management Act came into effect in 2015, and it repealed earlier statutes, the Disaster Preparedness and Emergency Management Act. And pursuant to that act, a body corporate was established to be called the Office of Disaster Preparedness and Emergency Management. And the principal objects of that office was to advance disaster preparedness and emergency management measures, and to implement integrated disaster management systems and institute measures for mitigating disasters. Then the functions of the office were, of course, to ensure that those objects were met. So they included developing and implementing policies and programs to achieve and maintain the appropriate state of national and sectoral preparedness, and to provide for training programs and public awareness of disasters. The duty of the office was to advise the minister on issues relating to disaster management, prepare guidelines, initiate plans, and for overall framework for disaster risk management. In Section 2 of the Act, disaster and hazard are defined. Disaster means the occurrence or threat or the occurrence of an event or other calamity, whether caused by an act of God or otherwise, which A, results or threatens to result in loss or damage to property, damage to the environment, or death, ill health, or injury to persons on a scale which requires emergency intervention by the state. And B, may result from fire, accident, an act of terrorism, storm, hurricane, pollution, disease, earthquake, drought, flood, the widespread dislocation of the essential services, or other calamity. And hazard means a natural or man-made phenomenon which is likely to cause physical damage, economic loss, or threaten life, well-being, or property. Part 5 of the Act deals with the declaration of disaster areas. Section 26 empowers the minister to give written notice to the Prime Minister of the existence of a local condition which is endangering public safety in the circumstances in Jamaica, or is threatened by a natural or anthropogenic hazard. So as a consequence of that report, the Prime Minister may declare the whole or any part of Jamaica to be a disaster area or a threatened area, and shall publish that order in the Gazette. And he shall direct enforcement of certain measures recommended by the office, like removing and guarding against mitigating as far as possible the disaster or the hazard. Now, the order will remain in place until it is revoked or another is put in place. But the Prime Minister can only issue it if he's satisfied that there is a disaster occurring or is imminent, and these extraordinary measures are required to prevent or minimize the loss of life or harm to health of persons, destruction or damage to property, or destruction of or damage to any part of the environment. And once this order has been put in place, authorized officers are given the power to, they're involved in all sorts of measures to direct evacuation of areas or particular premises, destroy, remove, dismantle, or demolish vehicles or buildings. Now, this situation has been in place from March 2020 until March 2022. And during that period, a series of orders called disaster risk management enforcement measures have been put in place. The first one was put in place on Monday, March 16, 2020, and it stated that it was effected pursuant to 26 sub 2 of the Act. And many measures were put in place for persons to self-quarantine and to inform the ministry if they had flu-like symptoms or if they'd come into contact with anybody who had traveled in a country that had the virus. And it restricted persons to amount of 20. And it was also directed that people should work from home without any adverse consequences. And also, a lot of places, as my colleague or our doctor had indicated, were closed. And that included cinemas, dance halls, clubs, all sorts of places. And then subsequent to that, it directed the closure of places of worship and limited to very small numbers the attendance of persons at weddings, funerals, and later burials. And then there was the strict curfews. So you had to be in your home after a certain hour, and in sometimes no movement at all. So mass social distancing and regular sanitizing became a way of life. Then there was the policy in relation to the vaccine, but that wasn't ordered under Section 26.2, and it was not published in the Gazette. So we've had all of these orders, but they were revoked by the by Section 16.1 of the Public Health Act that brought out different orders, which are now called the Public Health Enforcement Measures Coronavirus COVID-19 Order. And these required owners and operators of certain establishments, including places of worship, and all places that have facilities to have hand washing or sanitizing and masks. The importance in relation to these new orders that are coming under the Public Health Act, though, is that they do not have any provisions for curfews or restrictions on the number of persons accessing public places, including places of worship or motor vehicles. So moving on now to the challenges that have come out of these restrictions. Remember, we've had them for 2 years, and so the restrictions have brought about challenges in the court. One of them is from a registered religious company who sued the Attorney General for several orders and declarations. What were those? In the main, that Section 26.2 of the Act was unconstitutional because it was in conflict with Section 20 of the Constitution. That restriction of the company's right for freedom to express its religious practices was guaranteed under Section 17, and so any restrictions were null, void, and of no effect. And then also that the failure of the government to invoke the provisions of Section 20 of the Constitution and proclaim a state of emergency, yet restricting the company's right of freedom to express its religious practices, was null, void, and of no effect. The company invoked that the provisions of the Act could not be claimed as they were supposed to protect an outbreak of infectious diseases, namely COVID-19, but that was already properly addressed in Section 20 of the Constitution, and that required the Governor General to declare a period of public emergency existing, and it could only be done if the Governor General was satisfied that a period of public disaster had arisen, and as a result of an outbreak of an infectious disease or other calamity, and that was Section 20, subsection 2C of the Constitution, and none of that had taken place from the Governor General. So that said company, that was a religious company, it had in excess of 10,000 persons. They were very effective in their community. They were looking about food and clothing and healing of persons in the community. They went to church 7 days a week, and they had Sunday school classes, and they were very involved in religious practices. So they claimed that their democratic rights generally had been infringed, and their specific rights to freedom of movement had been infringed as well, and in relating to their religious activity. And there were other persons who had been affected by these ordinances. Persons were arrested and charged, and they had been basically because they had breached curfew or they were not wearing masks, and some persons were fined, and those persons who were fined and couldn't pay the fine were incarcerated. There were those who were overcome by frustration of not being able to work on festivals or to work in the tourism and entertainment industry. Many families felt their livelihood and well-being were threatened. Some persons would say this equated to depriving one of the right to life. One may query with force, how can one live without a means of living? And the means of living is earning a livelihood. The issue of maintaining one's livelihood, therefore, is a substantive challenge arose out of national concerns with regard to taking of this vaccine against the transmission of the disease, which translated from many commercial organizations to creating policies that required the employee to prove that they're taking the vaccine, and if not, to show that they're done 2 PCR tests every 2 weeks at their own cost to prove that they were COVID-free. So claims were definitely filed to challenge these policies on the basis that there were constitutional breaches as well as breaches of the employment contract. They were saying, shouldn't one have a constitutional right to refuse the insertion of a vaccine or any instrument into one's body without having to provide reasons, particularly in circumstances where one is not exhibiting any symptoms? And also, shouldn't one have the right of refusal based on one's religion and conscience, especially if one believes that the vaccines were researched, developed, and or manufactured with the aid of cells that are derived from aborted fetuses in contravention of one's Christian faith? Can an employee be forced to take one of the vaccines in contravention of one's belief and opinions? Can an employee impose an obligation, including a financial obligation, on an employee without his consent, which is an amendment to his contract of employment? And does an employee have the right to divulge private and confidential medical information relating to his vaccine tests to his employer? Does the employer have the right to prevent employees from entering the workplace if unvaccinated without results of a PCR test? Also, can an employer enforce unpaid leave and therefore deduct funds from one's salary on the basis that the employee is allegedly deemed to have been absent from work? Shouldn't it be a breach of his right to work when he's willing to work to force him to take vacation leave? Are these not fundamental rights guaranteed by the Constitution? Isn't the employer obliged to respect the fundamental rights and freedoms of employees? Wouldn't the policy requiring the employee to be vaccinated with no other reasonable option be in breach of the contract of employment and also a constitutional right? The claims on behalf of the employee, therefore, are that the employee's policy is based on a design that is unconstitutional. It places punishing burdens on the employee exercising his constitutional and contractual right, breaches his human and fundamental rights to his livelihood, his security of person, his liberty, his personal belief and conscience, and his private life. These fundamental rights, as claimed, are all being infringed. It's also claimed that the employer cannot demonstrate that the policy is justified in a free and democratic society. The employer's response is that this is all about a contract between an employer and an employee, and the employer must be able to implement policies that are for the protection of health of the individuals at the workplace. And if those terms are not in the employment contract, then the employer should expect that any policies that are developed from time to time would be implemented and incorporated. And the employer said it's a common law duty of the employer to provide a safe system of work, which includes taking reasonable care of the health and safety of its employees, which involves not permitting them to be exposed to unnecessary risk. And a policy requiring vaccination in a pandemic is a meaningful one and will assist the company to restore normalcy in the workplace. The employer must also be mindful of other statutes like the Occupiers Liability Act, so that when persons are coming to visit the environment, they are also protected from health risks, and the Labor Relations and Industrial Dispute Act as the Labor Relations Code, which also require the employer to adopt suitable measures for the workers' protection and their general welfare. Additionally, the employer said the policy does not require the employee to be vaccinated. The employee has a choice and can exercise his right to do that or not. And in any event, the position taken by the employee is just really a matter between the employer and the employee. So the employer's assertion was that the vaccine or the PCR test will assist in protecting the health of all employees. The terms of the policy could therefore be considered reasonable, proportionate, and justified. However, in the circumstances as described, the employer maintained that one could readily conclude that there were no constitutional rights, not even engaged, much less being infringed in any way. So in relation to the challenges, one would want to look at what could be the constitutional rights that could be affected here. Sections 13(1), C2, 3A, B, J2, B, and S, 14, 17, and 19. Well, the Charter in its preamble acknowledges the obligation of the state to promote universal respect for and observance of human rights and freedoms. All persons in Jamaica are entitled to preserve for themselves and future generations the fundamental rights and freedoms to which they are entitled by virtue of their inherent dignity as persons and as citizens of a free and democratic society, and that persons have a responsibility to respect and uphold the rights of others, 13(1)(c), and that the provisions set out in the Charter shall have the effect of affording protection to persons mentioned therein to the extent that those rights and freedoms do not prejudice the rights and freedoms of others. So the rights set out are guaranteed as may be demonstrably justified in a free and democratic society. Now, I notice that I'm running out of time, so what I will just indicate to you is that there are certain provisions in the Constitution that perhaps one would think would be rights that would be applicable to these challenges that I have outlined. The right to life, liberty, and security of the person. This protects an individual's personal autonomy, because in a free and democratic society, the individual must be left room for personal autonomy to live his own life and to make decisions that are of a fundamental personal importance. Now, in the case of Junior Robinson versus the Attorney General, the full court acknowledged that the right to life, liberty, and security of the person extends beyond the physical restraint of the person and includes protection against any forced intrusion on the part of the state. Arguably, this should not be limited only to the state, but also to that of a private citizen. There is also a very important right, which is the right to freedom of thought, conscience, belief, and observance of political doctrines, and also the right of the freedom of religion. Then there's the right to equality before the law, but that only relates to an instrument of legislation and also the common law. The right of privacy is very relevant, and it involves not only bodily, mental, and emotional integrity, but in a free, and this is coming straight out of the NIDS case, in a free and democratic society, recognizes that an individual has control over whether his or her biographic and demographic information is shared and under what circumstances the sharing takes place. So it is interesting that privacy does not only require assault, physical intervention, or treatment, forced examinations, or entry to the body. So lastly, I would like to deal with how does one interpret the Constitution? Normally you would say, approach it just to, as one would normally do a statute, and look at its ordinary natural meaning. But we have had help from the law lords, and in the Patrick Ray's case, it is clear that when you're dealing with constitutional provisions, you should give it a generous and purposive interpretation. And when you're dealing with limits and restrictions to the Constitution, they should be construed strictly. Now, in terms of constitutional challenges, you first have to identify the constitutional right. Then you have to show that the right has been infringed. And then the person who is violating that right has the burden to show that the limitation is justified in a free and democratic society. In the Oakes test, it is said that there are two central criteria for that. The first is the objective, which the measures responsible for a limit on the charter right or freedom are designed to serve must be of sufficient importance to warrant overriding a constitutionally protected right or freedom. Second, once a sufficiently significant objective is recognized, then the party invoking the exception must show that the means chosen are reasonable and demonstrably justified, and that test has three components. First, it must not be arbitrary, unfair, or based on irrational considerations. Second, the measures must be rationally connected to the objective and should impair as little as is reasonably possible the right or freedom. And finally, there must be a proportionate relationship between the effects of the measures reasonable for limiting the right and the objective identified to be of sufficient importance. There are two last areas I'd like to deal with in relation to constitutional interpretation and importance, and that is that usually when you're dealing with the challenge to constitutional rights, you're talking about the vertical application of rights. That is an abuse of the state against the individual. With the advent of the Charter, you now have horizontal rights, which is between equal parties having equal challenges, equal rights. And so the court now has to look at it on a balancing test, and there's no proportionality on both sides. Proportionality in relation to both competing rights of equal parties. And then lastly, I would just deal with Section 19. Section 19 of the Charter speaks about, do you have standing? To show that you have standing, you must first show that the right is related to you personally, so that you will be affected by it and you will have a legitimate interest in the outcome. So you're not a poser or an officious bystander. And of course, the process to do so in the civil procedure rules. So in the circumstances of the challenges that I have outlined, if an employee can identify the charter right and can show by evidence that it has been breached, then you would have the legitimate basis to go to court and show that you have standing to claim whatever redress it is that you would wish. In 19.3 and 19.4 of the Constitution, however, there is a carve-out that even though you're able to show that you have a constitutional right and there's been a breach, the court can say that the matter should be dealt with in another appropriate court in the Supreme Court. But the fact that there's an alternate remedy does not mean that you will not be able to have your matter dealt with in the Constitutional Court. So, in closing, it is pellucid that there are bases for fulfilling all of the challenges that I have spoken to in relation to restrictions posed on citizens due to the unfortunate rampage of COVID-19 virus throughout the country. The claims are making their way through the courts. Some aspects of them have been heard and determined, but the decisions are on appeal, and others are still awaiting their day in court. It therefore would be imprudent at this stage to make any comments on the decisions already made or on the potential outcome of the claims, or to give any opinions on the merit or the challenges which have been made. It's a developing area of the law, and we should hope that we will not often have to deal with issues pertaining to the rights of persons and the restrictions thereof under circumstances of a global pandemic. Thank you.
Thank you very much, Ms. Justice Hillary Phillips, CD QC, for your ultra-efficient use of time, packing so much on the Constitution into the limited time. We will, of course, have development of that in the question and answer session. Our final presenter is the immediate past president of the Jamaican Bar Association. He was recently appointed managing partner of Dunn Cox, where he practices employment law and commercial litigation. He's a member of the Jamaica Chamber of Commerce and chairperson of the Industrial Relations and Labor Law Subcommittee of the Betting, Gaming, and Lotteries Commission. He's a former commissioner of the Fair Trading Commission, former president of Jam Damas Running Club, a primary organizer of the internationally known Reggae Marathon, but I assure you, he won't be doing a marathon this afternoon when he presents on COVID-19 and employment issues. Please, ladies and gentlemen, join me in welcoming a Bethelite, dedicated here as an infant, later becoming a member, from our legal aid clinic, attorney at law, Mr. Emil Leiber. Emil?
Thanks very much, Andre. I will endeavor to be more like Usain Bolt than I will any of our Kenyan brothers in the Olympics. So, you know, one of the things that we say about employment law is that it affects everybody in Jamaica. Everybody is either an employer or an employee at some stage in their lives, all right? Now, COVID-19 kind of highlighted some very specific areas of employment law that had not really gotten a lot of emphasis before. Now, this presentation will be somewhat retrospective and prospective, meaning that what are the things that happened to employees during the course of COVID, and what are the things that they are currently still undergoing. So the first is layoffs. Next slide, yep. So layoffs. Now, layoffs, like many areas of employment law in Jamaica, are not fully fleshed out in our law. What does that mean? So the Employment Termination and Redundancy Payments Act is the only act that really speaks to layoff, and it is layoff due to a change in circumstances. There is also what they call the contractual right of layoff, meaning that do you have a policy or something in your contract of employment that allows an employer to lay you off? Now, the vast majority of employers in Jamaica do not have what I call comprehensive contracts and policies. So when COVID came around, when places shut down, when places were on lockdown, when the airports were basically closed, a lot of businesses had to ask themselves, what do we do? And the answer to that for most of them was to engage in layoffs. So layoffs are basically a suspension of employment, of the employment relationship. Now, the employment relationship is basically one where the employee agrees to work and the employer agrees to pay them, right? So if one doesn't do their role, then that is what they call a fundamental breach of the employment relationship. But in a COVID-19 situation where they engaged in layoffs, business was suspended, right? So the employer said, well, I don't have the ability to pay you or to continue paying you because my business is not continuing to generate income for me. And so they suspended the employment relationship as versus terminating the employment relationship. And so that suspension, of course, resulted in employees not earning an income. Now, some employers had the employees on half pay and quarter pay and that type of thing. So there was some variability regarding how the layoff structure took place. And then you had questions like, do I continue to accrue vacation leave while I'm on layoff because I'm still employed? However, what I would say the better view was that you accrue vacation leave 1 day for every 22 days worked. So if you're not working, then the thought is that you're not accruing vacation, right? No, that was not really ever settled, but that is kind of where we landed. So, you know, one of the things you'd see from labor law or employment law generally, and certainly in the COVID period, is a bit like the Wild Wild West. You kind of shoot from your hip, because from 1976, most of our labor laws have not been updated or amended to reflect the current employment situation in Jamaica. So we then got into the circumstance of mandatory vaccination. So now many may say, well, this is less of an issue now, and Justice Phillips quite ably addressed some of the legal issues relating to you know, those types of policies and the circumstances in which they took place. But for many people, mandatory vaccination became almost a religious point that, you know, God would not want me to get a joke. You are breaching my religion, my religious rights, all my freedoms by forcing me to take this job. But then when it is that these types of issues and concerns arise, again, you start to ask yourself, go back to fundamentals. What is the nature of the relationship between employer and employee? Now, it's largely contractual. As Justice Phillips has said, there is some parallel application of constitutional issues, and there are also statutory obligations that an employer has. But one of the things that employers strongly relied on is the whole question of safe system of work. Now, the objectors would say, well, whether you're vaccinated or not vaccinated, you can catch COVID, so how that making me safer? Or even more importantly, that even if you are vaccinated, you can still catch COVID and pass COVID. Or you can transmit it to someone else. And forgive me if I say anything medically incorrect. I'm sure Julia will correct me later on. And so in that context, is it a safe system of work being created by virtue of, well, we won't say mandating, because again, what the court said is that you had a choice. You could choose to submit the COVID-19 test results on a regular basis or get vaccinated, or you could take some time at home to think about that and your future prospects and what you'd like to do, you know. And so you had a multiplicity of options while it is that you're contemplating the implementation of the vaccination policy of the particular employer. Now, my view regarding that vaccination was always been that it was best implemented from a government perspective, because certainly at one point, as Julia had indicated, the hospitalization rate was over 100%. So that is a clear context in which one could have implemented laws to say you must get vaccinated, right? Because there is a clear public health issue. It was, we were under disaster for 2 years. The question as to whether or not that was the appropriate piece of legislation for that 2-year period is open now that it has been revoked and remains open, but there are certainly many other issues arising from that. So next slide. So if you got to the point now where you said, you know, boss, me and you been together for a while working, but this is not working out, or the employer could initiate that discussion to say, well, you know, you've been a good employee, I like you, but you're not getting vaccinated, and, you know, this is not going to work. This relationship has broken down. Everybody knows the expression, it takes one hand can't clap. So in every relationship, and that includes an employment relationship, both of you need to be on the same page in order for it to work, all right? So, next slide. If it is that it doesn't work out, one of the most amicable ways that you can end the employment relationship is by mutual separation. Now, you know that you can get terminated, and if you're unjustifiably terminated, you may then end up in the Ministry of Labor and Industrial Disputes Tribunal. Or if you're in the teaching profession, Mr. Earl will ably represent you. Not limiting his practice, of course, but certainly he will very ably represent you in all the necessary tribunals in that regard. But one of the best ways, I would say, from an employment law standpoint is you part as friends. You say, you know what, this isn't working out, let's agree some terms on which we both part company. And so, as we had said earlier, the employment relationship is fundamentally a contractual one, so you can both agree to end that contract on mutual terms. So, such an ending should take the form of a written document, signed, of course, by both parties, whereby you have an agreed date of separation that the employment ends, you have an agreed package, and you have a release of any potential claims that may arise from that termination. And that is where the employer and employer says, okay, this amount is the amount, or these are the terms on which, this is the time within which we want the separation to take place. Many times employment disputes arise simply because of how they were handled, all right? Them run me out of the place like thief after 20 years, and that type of thing features very heavily. The way in which they treated me, you know, so it's a very emotional thing when employment ends, or it can potentially be an emotional thing when employment ends. And so the mutual separation scenario is really one of the better ways in which, if yourself and your employer, or if you're the employer, yourself and your employee can sit down and negotiate terms upon which to set part as friends, hail up each other in the street thereafter, and, you know, have no animosity. All right, next slide. So let us say you decide to remain at work, but you now realize that, you know what, this traffic, since they've had the full face-to-face school thing, is entirely unproductive. I'm wasting far too much time getting to work and getting back in the evenings. I will be much more productive at home. Of course, that is a hypothesis that doesn't always fulfill its expectation. But under Jamaican law, thankfully, you can have a remote working scenario. And that remote working scenario is, of course, supported by the Flexible Work Arrangements Act 2014, I believe it was passed, and a robust remote work policy. A lot of times people would ask, oh, can I work from home? And they said, sure. You take your laptop, you plug in at home, and you're fine. However, you don't think through all the possible permutations that can take place in a remote work environment. Now, one of the first issues is one of security, because usually it is your work laptop that you will have, that you will have brought home. Not every home environment is ideal for remote work in terms of, is it doubling as the family laptop? Are your children on the laptop? Doing things that they should or should not be doing. Now, they have some employees too who said, well, I don't even need to be in Jamaica because I have an internet connection everywhere. Yes. And so, what is the impact if I choose to work in another jurisdiction? Now, that of course, raises other issues altogether, because you are an employee in another country. Now, though the employment laws of that country may apply to you, even though you are a Jamaican working for a Jamaican company, you might, under the laws of that country, qualify for the definition of an employee and other statutory rights and obligations which the employer never imagined might arise, and they may find themselves subject to the law of another jurisdiction that they never intended to. Right? Now, then you have the situations where the employer says, you know what, I'm tired of looking at all these empty cubicles. Right? All of you must come back to work. Now, let's say you made arrangements based on the fact that you are remote and working remotely, rather. How much notice should you be given? Should it be a next day? Should it be on demand? I can call you back at any time. You're like a fireman. Anytime I touch that bell, you must jump and bring your hose, right? Or is it that reasonable notice should be given before of a request to return to the office? And then there's also the element I had mentioned earlier about productivity. Is there any measure by which the productivity should be weighed or can be weighed by the employer? Now, some employers, I think that's more prevalent in the U.S., have taken things like monitoring the equipment, right, of the employee who's working remotely. They might even use the camera to see whether or not you are, your head is up, you're focused, or, you have decided to meditate during working hours, right? And so there are also privacy issues that arise from things like that. If your employer can control your camera remotely in your home, and we all know that there have been many instances of unintended visual sharing that took place when, the whole question of Zoom and all of that came in. So when your employer controls your machine that has audio-visual access to your home, that also raises questions for you. Next slide. So as I conclude, COVID-19 placed a laser focus on many areas of employment law that were not previously front of mind. It remains to be seen whether some or all of the changes are permanent, or whether we will all, perhaps by the end of 2022, go back to business as usual. Thank you very much.
All the panelists, I want to thank all the panelists, Dr. Julia Rowe Porter, Miss Justice Hilary Phillips, and Mr. Emil Leiber for their excellent presentations. And we're going to move straight into our panel discussion now. And I'm sure you want to ask some questions of the panelists. We're going to invite you to do so by posting your questions in the chat, whether on the Bethel website or on YouTube. Dr. Porter, until we get some more questions, let me just pose this to you. Thanks again for your presentation. Based on the extensive information which was disseminated by the Ministry of Health and Wellness, were you surprised at the extent of the vaccine hesitancy on the part of Jamaicans? in relation to taking that vaccine?
Okay, thanks for the question. And there was an expectation that there would have been some hesitancy because essentially you're introducing a new vaccine into our population. It happened with introduction of the human papillomavirus vaccine to school-age girls. There was pushback with that. So we knew that there had to be massive public education. And it's really since recently that globally vaccine hesitancy is an issue. And not just with new vaccines, but all vaccines. And this is for various reasons. And in fact, vaccine hesitancy has been described as a major public health problem, not just a vaccine-related problem, a public health problem, because it's undermining the achievements of the global vaccination program. It's very complex, and it really is due to several factors: lack of trust, the mode of administration. So I'm being mischievous, but I say to myself sometimes, if they had put the vaccine in fried chicken or a soda, then you wouldn't have a problem. They would, because I mean, salt and fat, they'll kill you, really. They're unhealthy, but I'm sure if they put the vaccine in there, you wouldn't have a problem. It's in an injection, it hurts, it's a needle. Jamaican people afraid of injection, and you're giving them something when they're well. You know, we're not preventive-minded, we're treatment. So if you're going to stick me, it's because I'm sick. So it was expected. So the ministry knew they had a lot of work to do to communicate and increase acceptance for the vaccine.
All right, thanks for that answer.
I think,
Justice Hillary, you wanted to add to that?
well, I was going to say that there was so much misinformation also that was out there in relation to what the vaccines allegedly could cause, because there was this I mean, what I said in the paper, that many people believe that it was manufactured and developed from these aborted fetuses and other things like that. And so that would definitely encourage people to take a stance that they weren't going to be interested in any vaccinations. But I think it made it harder to not only have to give public awareness of what you were hoping to do in terms of public health, but you have to cross all of this misinformation that was there and not based on anything, perhaps.
All right, question to you, Justice Phillips. The whole matter of the wide nature of the DRMA, Disaster Risk Management Act, based on the wide nature of the orders, were you surprised that you didn't have more constitutional challenges?
Yes, I was actually. I was surprised that it was practically at the end of these 2 years that suit has come from this registered religious company, actually asking for a declaration that the provision, section 26(2), and that is the section under which all of these orders have been made, is unconstitutional, and that's at the end. And also the fact that, you know, there's this provision in the Constitution, section 20, that should have been applied. I mean, I don't know, we have not had, that matter has not been heard, and I don't know what how the arguments will develop, but I actually thought that there would have been more challenges.
Thank you for that. Emil, you wanted to add to that?
Yes, Andre, it was interesting, given the position I had at the time when COVID hit and the DRMA orders and so on came about. Certainly, I would say from the Bar Association perspective, it was a thought. I wouldn't say it was a heavy discussion, but certainly my, said hashtag personal view was that we wouldn't want to create disruption and uncertainty in this time when there's already so much disruption and uncertainty. And so, to my view, a challenge to the law when COVID was running hot and people were, even the act of challenging in and of itself would make people uncertain about compliance and whether they should do this and do that. And I do believe that there is, our former Prime Minister, P.J. Patterson, once famously said, the law is not a shackle. But I think the law should work with society as versus contrary to.
I think also if we remember, I mean, you have to put yourself back in the beginning of 2020 when, I mean, a lot of people were dying and it was really a very difficult time and their healthcare workers were under pressure and your hospitals were also under pressure. And so you had to be thinking, well, if it was such an attack on the health of persons, then maybe it would be easy for the state to show that it was justified in a free and democratic society. And therefore you would wonder if that's the way you should be taking up your time, as opposed to trying to help with public awareness and trying to get people to understand how to go about sanitizing and masks and, you know, making sure there's social distancing and doing all the things to protect each person and their fellow citizen, as opposed to going to the courthouse at the time, because, you know, you have to remember what it was like. I mean, just about, there became a time when just about every other person that you knew was suffering, was severely affected.
All right, thanks for that. Emile, I'm sure a lot of the attendees at this webinar were very intrigued by this whole matter of remote work. Going forward, do you think our labor laws will have to change to accommodate remote work and all that involves?
Well, actually, no, I don't think we need a legislative amendment for remote work. It's really about the individual employers tailoring their policies to meet their requirements, because there are a lot of different considerations depending on sometimes the industry you're in and the nature of what you do. And then if we're waiting on the legislation, I can tell you, we would be in a difficulty. But I think where there are legislative gaps, thankfully, this is an area that can be covered by contract. But it is incumbent on the employers to not just have word of mouth, you know, because I don't have the statistics, but many contracts, or many employment contracts in Jamaica are oral. So as we think, even from a domestic worker standpoint, I'm sure many of us do not have written contracts with those who provide services for us in our homes and to our children, you know. And so it is incumbent on the employers and the employees to ask for it if it is not in place, because the employees also benefit from certainty as to how something is going to work, rather than it being capricious, where 1 minute them say you can go, next minute they say you can't. And, you know, if you have a framework within which to operate, that is always best for all concerned.
All right, thanks for that. We have a question from the Bethel website. Nicole is asking, if someone dies from COVID, is the insurance company obligated to pay the claim, seeing that COVID drugs are deemed experimental drugs?
Well, I would say that is dependent on the terms of the policy.
I was about to say the same
Yeah, it
thing.
would be dependent upon the terms of the policy or the individual policy, but most policies of insurance would cover death from illness, and I doubt the insurer would have rapidly amended it to exclude COVID-related death.
But I'm not sure why the fact that you're using experimental drugs should affect the insurance paying for death if it's a policy that's covering death. It's not like it's suicide or anything like that. I'm not sure why it wouldn't be covered.
All right. Another one here, Mr. JT on YouTube says, I work at a company that does random COVID testing, but there's no COVID policy. It was not discussed with workers, and we did not sign to it. Is it legal?
Well, we can't speak to individual circumstances necessarily, but I would say a COVID test, as I understand it, involves someone putting something up a nostril in a rather uncomfortable way and moving it around. Now, any touch, as far as I know, that is not consented to would be some form of assault. And therefore they can't hold you down and randomly test you for anything, whether it be drug tests or anything like that. Most employment policies, if it's actually in writing, would say, for example, if you fail to submit yourself for the test, then that can be a breach of your employment contract. But there's no inherent right in an employer to hold you down or to force any type of physical test upon you.
I think also there was some very strong dictum out of the NIDS case that would suggest that it has potentially a breach of a privacy right. So one would have to look carefully at that.
And I also want to add, we're currently operating under the Public Health Act, which states no that testing results are private and confidential. So we have to consider that going forward as well, because it's written in the Public Health Act, in the order.
That's a very, very important point there. All right, now the question, Justice Phillips, to you. Given that the DRMA orders have been repealed, what is the effect now of the constitutional action before the court? If the court were to order that the orders were in fact unconstitutional, what would happen next? Is that just a Pyrrhic result?
Most of these cases seem to be asking for declarations. And so I suppose they will get the declarations first to see what was the situation, and then after that to see whether or not there is any redress that falls as a that is consequent as a result of those declarations, because there may have been a lot of damage that you may have suffered while persons were acting under it, and if it was unconstitutional, then it would follow that the court would have to look at that.
All right, thanks for that. Dr. Porter, I have a question here for you. Suppose a more lethal variant of the COVID virus was to emerge tomorrow, God forbid, and vaccination was effective in stemming its spread. In your opinion, what is the single action which could be taken to increase vaccine take-up?
That's a very good question. I'm going back to what happened with the Delta variant in September, that we had our highest death rate. That was the most, what we call virulent or deadly strain so far. So we really could, in fact, have a new variant that is just as deadly or even more, God forbid. I think we're at a point where, and let me say, I think one of the main factors affecting the low coverage was lack of trust with the misinformation. And I believe there is a place for using more community-based partnerships to expand the vaccination program, not just the vaccination program giving the vaccine, but the messages. So if I say something and I am from the Ministry of Health, then your ears are closed. But if you say something to encourage someone to get vaccinated, it has a totally different effect. If they hear it from their pastors, if they hear it from the man on the street, if they hear it from their mother, father, sister, brother, if they hear it from other persons that are influential in the community and support and have the vaccine widely available, where you can walk into your doctor's office and have a conversation with your doctor about some of the barriers or the misinformation, then I really think that would make a big difference. And that's, I think, what a lot of other countries did, where they broadened the access, they involved their private sector early, people had access and had conversations and counseling, and that helped to dispel some of the myths and increase the uptake. So people understood the value of it, the importance, the significance, the social responsibility, and the uptake was high in some of those countries. So I think that would be the single most, the community involvement.
All right, thank you for that. Emile, have another question here for you. While other countries have seen what they call the Great Resignation during the pandemic, Jamaica saw more layoffs and redundancies. Do you think our labor laws influenced what happened there?
Well, the Great Resignation, as I understand it, really arose from people saying that I'm not going to work in this way anymore. You know, I've experienced something different. I've experienced a different way of living, and I'm not going to go back to business as usual. Now, in the Jamaican environment, those who were laid off from work required an income. You know, the portability of labor, depending on your level of qualification in Jamaica, can be very limited, actually, because we are such a small economy and such a small environment. we don't necessarily have the breadth of options that they do in other countries. And so I think we would be very unlikely to have a great resignation here, because if you're in finance, you have maybe 5 companies you can work for. You know, if it's in even a legal space, it's relatively few options. And so I don't think it is the state of our law that would prevent something like that. I think if people did have more options, then sometimes they perhaps would choose to exercise them. But in Jamaica, we are simply limited by the size of our market in terms of just the flexibility and portability. And so even regardless of the state of our laws, I don't think we would ever have a great resignation in Jamaica.
You know, this whole matter of the way we're impacted by COVID, I just wondered, Justice Phillips, how it was for you when you were sitting in a court of appeal and had to innovate, change the way the court did things and conducted hearings. How would you say the court was impacted in the delivery of justice by the COVID?
Well, I have been sitting in the Court of Appeal for the last 12 years, so it was a little bit different because we didn't have a situation of jury trials or viva voce evidence being taken. So it was really submissions, and so those submissions were done online. We were very early on the Zoom platform, and it was new and it was difficult, but I have to say counsel were very accommodating, and we have a very efficient registrar, and so things ran very smoothly, and the judges were fitted into that system very quickly. I think it would have been much more difficult in terms of when you have to have persons giving evidence, because that would have been far more challenging. But in terms of our court, there are many attorneys who are pleading with us to go back to face-to-face. They find that it's not as potent. They don't feel as comfortable. Sometimes they say they can't see the judges properly. They can't see their demeanor. They can't get a feeling of what's happening in the courthouse. It's just not the same. And so they would really like to go back to person. And I think most courts are trying to do that and trying to see, depending on what the COVID situation is, that maybe by the end of the year, we'll all be back to face-to-face. But it has to be subject to health challenges, of course.
All right, thank you very much. Well, we have come to the end, if you can believe that already, of our webinar this afternoon, going into the evening. And at this stage, I want to thank you all again, the 3 of you, for sharing so well in our webinar. We have taken quite a bit away from it. Now, this production, ladies and gentlemen, had a lot of moving parts. And I do want to express thank you to a number of persons. Firstly, the administration in the church office, the media team, Deacons Lawrence Brown and Michelle Smith and Gary Callum, Sister Margaret Anderson for the beautiful backdrop that you see here this evening, the production team, Deacon Trudy Morrison-Reed and Sisters Moya Thomas and Roxy Nickel, the GRIP Executive Assistant Caretaker, Mr. Vaughn Lynch, and the entire Bethel Baptist Legal Aid Clinic coordinating team, led by my learned friend and Sister Sola Hines. Now, there's, of course, the BTS crew. The BTS crew stands for behind the scenes. I want to thank all those persons who made this a reality. And as I prepare to wrap up the forum this evening, let me just invite each of the panelists to get the opportunity to offer a closing comment of about 30 seconds or so, starting with you, Dr. Roporter.
Okay. COVID still a keep, right? And the impact is still fresh. Public health interventions work. They've been around for decades. Even in the Bible, you hear about quarantine, right? They're not new because they work, but they're only as effective as the population's acceptance and adoption of them. So I implore you, think critically, get the right information, make the right decision, protect yourself and your family.
Yes, and go ahead for me, please, Ms. Justice Phillips, with your closing comment.
I would say if one is going to try to ascertain whether or not one has a challenge that one can take to the court, you should just pause first. Try to identify what is that constitutional right that you claim is being breached, and then do your proper research. Find out the evidence that is necessary just to support whether or not there has been a breach of the right before you even think of challenging it. And then after that, you have to be prepared to answer the case from evidence disclosed from the person who is allegedly violating the right, to say, is it justified in a democratic society? So there's a lot to examine, there's a lot to ensure that you are familiar with before you proceed to say that my constitutional rights are being breached and I need to have redress.
All right, thank you. And Emile?
It has been said that the best way to hide something in Jamaica is to write it down, because nobody reads. I invite you all as employers and employees to ensure that you read your contracts, read your policies, and also communicate with employers and employees so that you can have an agreed position regarding how you are working now and how you think you should work. Because an employment environment always works best when there is robust communication between all parties.
All right, so thanks again to all three of you, Dr. Julia Rowe Porter, Justice Hilary Phillips, and Mr. Emile Leiber. Thanks also to you out there in the audience who have tuned in to this presentation on COVID and You Rights and Responsibilities, organized by the Bethel Baptist Legal Aid Clinic. As I close the proceedings and we continue to navigate these challenging times, let me encourage us, in the words of Maya Angelou, to try to be a rainbow in someone else's cloud. And if you can't manage that, then as Parish Court Judge Sancha Gay Burrell says, the least you can do is to stay positive, test negative. Have a great evening.